Hey, y'all. All right, we got 20 more Massachusetts real estate examination prep questions coming at you. Looking forward to working on these with you. Work hard, study hard. Good luck on your examinations, and we'll see y'all on the inside. Question number 1. Which of the following activities requires a real estate license in Massachusetts? Letter A. Hosting an open house for a property listed by a licensed agent. Letter B. Providing legal advice on real estate contracts. Letter C. Assisting a friend in selling their personal home without compensation. Letter D. Managing a rental property you own that has fewer than 4 residential units. And the answer is letter A. Hosting an open house for a property listed by a licensed agent. We definitely want to know when we need to be licensed and when it's okay. So this is a good example of a question that is kind of testing when it's okay to not have a license. So the answers that we were looking at, like providing legal advice, letter B here, on a real estate contract, you don't need a real estate license to provide legal advice. Now, again, be very careful. Providing legal advice when you're not licensed to do so is against the law. So don't give legal advice unless you're legally licensed to do so. Letter C, assisting a friend in selling their personal home without compensation. That's fine. One person can just help another person sell their home as long as you're not accepting or expecting compensation. And then letter D, managing a rental property that you own that has fewer than 4 residential units. That's something with anti-discrimination that we learned about in real estate courses. So that's out. So B, C, and D are out. But when we're hosting an open house for a property listed by a licensed agent, we absolutely do need to have a Massachusetts real estate license. Question number 2. What is the primary purpose of a purchase and sales agreement in Massachusetts? Letter A. To establish the property's appraised value. Letter B. To outline the terms and conditions of the property transfer. Letter C. To secure financing for the buyer. Letter D, to establish the property's market value. And the answer is letter B, to outline the terms and conditions of the property transfer. All right, so basic information about a purchase and sales agreement in Massachusetts, what it is. It's the purchase contract that we typically use in Massachusetts. It's called the PNS, or the Purchase and Sales Agreement. Sometimes in exams, by the way, they will call it the PNS, letter P, letter N, letter S, or the Purchase and Sales Agreement, okay? So it's basically amongst these to outline the terms and conditions of the property transfer. Question number 3. Which Massachusetts consumer protection law is primarily focused on safeguarding individuals' privacy rights? Letter A, the Massachusetts Privacy Rights Act. Letter B, the Massachusetts Fair Information Practices Act. Letter C, Massachusetts Data Security Regulations. Letter D, the Massachusetts Personal Privacy Act. And the answer is letter B, Massachusetts Fair Information Practices Act. So these are basically questions that we just want to know the basic things: privacy, consumer protection like 93A, Mass General Law Chapter 151B, which is the Fair Housing Act. And this one, the Massachusetts Fair Information Practices Act, deals with privacy rights here in Massachusetts. Question number 4. Massachusetts law mandates the installation of approved smoke alarms for which of the following? Letter A, the sale or transfer of homes built or modified after January 1st, 1975. Letter B, the sale or transfer of homes with more than 5 residential units. Letter C, the sale or transfer of all homes regardless of the date of construction or modification. Letter D, the sale or transfer of 1 and 2 family homes regardless of the date of construction or modification. And the answer is Letter D, the sale or transfer of one and two family homes, regardless of the date of construction or modification. So we need to know a little bit about the Massachusetts laws for fire alarms and smoke alarms and carbon alarms, and we go over those during real estate classes. In our program, for example, you'll see a bunch of content in the materials referencing that, location placement, type of alarms, carbon sensors, and such. So in many states, you're going to need to know this. Massachusetts is no different. You definitely want to know this stuff for your examinations. And as you're going through this stuff, that's what you want to know. Question number 5. Which of the following statements is true regarding real estate advertising requirements in Massachusetts? Letter A. Any ad must include the real estate agent's name and email address. Letter B. An agent can advertise a property listing that is no longer available in order to obtain buyer leads. Letter C. Real estate advertising cannot contain misleading information and must include the broker or brokerage's name. Letter D. Real estate advertising is not regulated by any specific laws in Massachusetts. Question number 5. Which of the following statements is true regarding real estate advertising requirements in Massachusetts? And the answer is letter C. Real estate advertising cannot contain misleading information and must include the broker or brokerage's name. That is absolutely something of importance that you many times might see on real estate exam, practice exam questions over and over and over. And Massachusetts absolutely has clear guidance when it comes down to bait and switch advertising and advertising, making sure that the brokerage's name is in the advertisement so that it's not a blind advertisement. So all of this stuff is essential for the exam. Question number 6. Which of the following is not a requirement for obtaining a Massachusetts real estate salesperson's license? Letter A. Completion of a 40-hour pre-licensing education course. Letter B. Having a Massachusetts driver's license. Letter C. Submitting a completed exam application including 3 candidate endorsements. Letter D. Passing a comprehensive written exam. Question number 6. Which of the following is not a requirement for obtaining a Massachusetts real estate salesperson's license? And the answer is letter B, having a Massachusetts driver's license. Okay, we want to know a couple things about what it takes to become a licensed real estate professional, salesperson, and what does it take to become a broker. So both of those are really important as you're kind of studying for these real estate licensing examinations. And obviously this one was fairly simple. This one was, which of the 3 is not a requirement and which 3 are requirements in essence. So you can eliminate A, C, and D as they are all requirements in order to get a Massachusetts real estate salesperson's license. Question number 7. Which of the following is true of landlords in Massachusetts regarding security deposits? Letter A. A landlord can use the security deposit for any purpose they see fit. Letter B. A landlord must return the security deposit within 60 days of the lease termination. Letter C. A landlord can withhold a portion of the tenant's security deposit to cover normal wear and tear on a rental unit. Letter D. A landlord must place the security deposit in a separate interest-bearing account and provide the tenant with information about the account, including the name and the address of the bank where the security deposit is held. Question number 7. Which of the following is true of landlords in Massachusetts regarding security deposits? And the answer is letter D. A landlord must place the security deposit in a separate interest-bearing account and provide the tenant with information about the account, including the name and address of the bank where the security deposit is held. All right, that was a mouthful, but you definitely need to know Massachusetts landlord-tenant rules and regulations. Massachusetts courses will typically cover those, so look for those as you will definitely see them. Now, just one note. keep in mind that the questions that they're going to be putting against you for Massachusetts landlord-tenant will typically be residential in nature. And in the commercial leasing sector, it's quite different. So just keep that in mind that, if you're in the commercial business and let's say you're taking this examination, you want to keep that sort of in mind, that it's all residential centric. These questions are going to sort of revolve around the residential rules and regulations here in Massachusetts. Question number 8. Which of the following accurately describes the renewal and continuing education requirements for real estate salespersons and brokers in Massachusetts? Letter A. Salespersons must renew their licenses every 2 years, while brokers renew every 3 years. Letter B. Salespersons and brokers both renew their licenses every 2 years and must complete 12 hours of continuing education courses. Letter C. Salespersons and brokers both renew their licenses every 3 years and must complete 40 hours of continuing education courses. Letter D. Salespersons and brokers both renew their licenses every 2 years with no continuing education requirements. And the answer is letter B. Salespersons and brokers both renew their licenses every 2 years and must complete 12 hours of continuing education courses. A simple question. We just need to know what it takes to renew the licenses here in the Commonwealth, and we just need to know that it's 12 hours every 2 years. Both salespersons and brokers will renew their licenses every 2 years. Question number 9. What is one of the key responsibilities of a real estate salesperson in Massachusetts when it comes to home inspections? And the answer is letter C. Providing all buyers with the home inspector's consumer fact sheet. Letters A, B, and D are all incorrect, and letter C is the only viable answer here. And then, in fact, that's the big requirement here in Massachusetts, is that we have to give the consumer the consumer inspector's, the home inspector's consumer fact sheet. And another thing to just kind of note is that here in the state of Massachusetts, a buyer's agent can make a direct recommendation to a buyer regarding a home inspector, although many times they give them a selection of 3 or 4 inspectors. And many times they'll just refer them to the state-approved list of home inspectors in Massachusetts. So that's another component that you sometimes will see. So you just want to know a little bit about home inspectors and home inspection, and this home inspector's consumer fact sheet is something that you want to know about as well. Question number 10. What is the requirements regarding the real estate licensee consumer relationship disclosure in Massachusetts? Letter A. Licensees are only required to disclose their agency relationship with the consumer once they are ready to submit an offer on a specific property. Letter B. Licensees must disclose their agency relationship with the consumer in writing at the first personal meeting to discuss a specific property. Letter C. Licensees only need to disclose their relationship to attendees of an open house. Letter D. Disclosure is not required in Massachusetts real estate transactions. Question number 10. What is the requirements regarding the real estate licensee consumer relationship disclosure in Massachusetts? And the answer is letter B. Licensees must disclose their agency relationships with the consumer in writing at the first personal meeting to discuss a specific property. This Massachusetts licensee consumer relationship disclosure form is absolutely, I'm going to say it, and I've said it before, is on the Massachusetts real estate examination. So you definitely want to look it up online if you can get a glimpse of it. Read through it really quickly, very brief, and understand it. And these are the components on quiz questions that you really need to understand: when we need to disclose, how we need to disclose, at what point, first personal meeting to discuss a specific property. And remember, they might play with you here. They might say that somebody calls in and talks about a specific property. Well, that's not first personal meeting. They might say somebody walks into a real estate office and asks questions about a bunch of different properties. And then you don't have to disclose agency at that point either. So you want to know these specific triggers when we disclose this particular disclosure form. Question number 11. Which claims are not permissible under Mass General Law, Chapter 93A? Letter A, a seller initiating a claim against the listing broker. Letter B, a business initiating a claim against another business. Letter C, a consumer initiating a claim against a business. Letter D, a business initiating a claim against a consumer. Question number 11. Which claims are not permissible under Mass General Law, Chapter 93A? And the answer is letter D, a business initiating a claim against a consumer. So we want to know a bit of information on Mass General Law, Chapter 93A. And as y'all are maybe familiar, it is the Consumer Protection Act. And I'm telling you, this is definitely on Massachusetts real estate licensing examinations. It is absolutely an important piece of what we do in brokerage. So you want to definitely know a lot about it. And you want to know here that claims are not permissible, are when a business is initiating a claim against a consumer. They can sue a consumer if they want to, but they cannot use 93A. Now, A, B, and C are all correct and are permissible under 93A. So a seller initiating a claim against the listing broker, that can be, 93A can be used for that. A business initiating a claim against another business, that can be, we can utilize 93A for that. And a consumer initiating a claim against a business, absolutely. However, D, a business initiating a claim against a consumer, is not permissible under Mass General Law, Chapter 93A, the Consumer Protection Act. Question number 12. Which statement is inaccurate regarding the requirements for a trust account in Massachusetts? Letter A, a licensed broker must oversee the account. Letter B, the account is intended to safeguard deposits from a real estate transaction until the completion of the sale. Letter C, a minimum of 2 designated sales agents are required to have access to the account. Letter D, the account must be maintained independently of the managing broker's private finances. Question number 12. Which statement is inaccurate regarding the requirements for a trust account in Massachusetts? And the answer is letter C. A minimum of 2 designated sales agents are required to have access to the account. So that's inaccurate. And letter A, letter B, letter D are correct statements regarding trust accounts here in the Commonwealth of Massachusetts. A pretty simple style question, but you're going to want to know some bits of information about trust accounts here in Mass. Question number 13. Which of the following statements is true regarding the Massachusetts Board of Real Estate Brokers and Salespersons? Letter A, they administer pre-licensing exams for real estate professionals. Letter B, all members must be real estate licensees. Letter C, they are elected by the Attorney General and serve a term of 4 years. Letter D, they oversee and regulate real estate brokerages and licensees. And the answer is letter D, they oversee and regulate real estate brokerages and licensees. So this is true of the real estate board. And they administer pre-licensing exams. Well, that's not true. We know that that's a testing center currently in Massachusetts. That's PSI Testing Services. All members must be real estate licensees. Again, that's not true. If you remember from the courses, 5 members, 3 of the 5 members are real estate brokers practicing for a minimum of 7 years, and the other 2 are just regular citizens of the Commonwealth of Massachusetts. They are all appointed, letter C, by the governor to serve 5-year terms. So we just wanted to clarify all of that, and that's a pretty classic question regarding the board. Question number 14. When one agent is handling the property listing and a different agent from their office is representing the buyer, the situation can be characterized as letter A, a case of a sub-agency relationship. Letter B, an instance where the managing broker acts as a dual agent. Letter C, an example of a designated agency relationship. Letter D. Both B and C are correct. Question number 14. When one agent is handling the property listing and a different agent from their office is representing the buyer, the situation can be characterized as, and the answer is letter D. Both B and C are correct. So we want to know a little bit about what is dual agency, what is designated agency, what is sub-agency, what is buyer's agency, what is seller's agency, and what is facilitator. And in this particular example, we are dealing with a scenario where we have a sort of designated agency relationship. And in that instance, there is a managing broker and they act as a dual agent when two members of the same organization are handling both sides of the transaction. So this is a classic designated agency style question. This is a good one, and I would focus on this one when you're trying to learn different agency roles. Question number 15. The Supreme Court's ruling in the McCarthy v. Tobin case determined that letter A, net listings are prohibited in Massachusetts. Letter B, offers to purchase real estate are legally binding contracts in Massachusetts. Letter C, dual agency is lawful in Massachusetts with the agreement of either the seller or the buyer. Letter D, dual agency is lawful in Massachusetts with the agreements of both parties. Question number 15. The Supreme Court's ruling in the McCarthy v. Tobin case determined that. And the answer is letter B, offers to purchase real estate are legally binding contracts. Per McCarthy v. Tobin, offers to purchase are binding. You learn that in the real estate courses, you learn it in ours. For sure, you want to know that. Per McCarthy v. Tobin, offers to purchase are binding. Now, net listings are prohibited in Mass, but McCarthy v. Tobin didn't establish that. Dual agency is lawful in Massachusetts with the agreement of either the seller or the buyer. That's not even true. It has to be the informed consent, affirmative assent of both parties. And letter D is a true statement, but has nothing to do with McCarthy v. Tobin. So letter B is the answer all day long. Question number 16. In Massachusetts, when a tenant requests accommodations for a service animal in a housing complex with a no-pet policy, the landlord, letter A, is permitted to request an explanation of the tasks the animal is trained to perform. Letter B, is allowed to inquire about the nature of the tenant's disability and the need for an assistance animal. Letter C, may ask the tenant to supply the animal's certification records from the state. Letter D, is required to allow the service animal without exceptions. Question number 16. In Massachusetts, when a tenant is requesting accommodations for a service animal in a housing complex with a no-pet policy, the landlord, and the answer is letter A, is permitted to request an explanation of the tasks the animal is trained to perform. Okay, this is classic, and you see these service animal style questions occasionally pop up on exam questions and practice exams that I've seen over time. And you just need to know a wee bit about them. I know in our particular course, we do cover service animals and sort of, the bits and pieces, so they're important to note. This is a good question. It goes a little bit deeper than most folks will go after, and the truth is, a lot of students might pick is required to allow the service animal without exceptions, letter D. But that's not the case. With a no-pet service policy in a building, the landlord is permitted to request an explanation of the tasks the animal is trained to perform. So letter A. Question number 17. The Commonwealth of Massachusetts exempts the following property owners from adhering to certain provisions of the Fair Housing Law. Letter A. Owner-occupants of dwellings with 4+ units. Letter B, owner-occupants of dwellings with 4 or fewer units. Letter C, owner-occupants of dwellings with 2 units. Letter D, any landlord of a dwelling with 4 or fewer units. Question number 17. The Commonwealth of Massachusetts exempts the following property owners from adhering to certain provisions of the Fair Housing Law. And the answer is letter C, owner-occupants of dwellings with 2 units. So remember, according to Fair Housing here in Mass, we shrink down the federal exemptions, which are 4 or fewer units, to 2 units and below. So here we want to know that it's 2 or fewer units. So owner-occupants of dwellings with 2 units or less. And remember, there was an additional carve-out with triple-deckers. If an elderly or infirm tenant occupies one of the units, then it's permissible to turn away a family with small children if that would be a burden on the elderly tenant. However, we cannot turn folks away because of lead-based paint if they have children. So there was that one exception that you do see on real estate exam and courses throughout the Commonwealth. So you want to know that, but this, generally speaking, is going to be owner-occupants of dwellings with 2 units or less. Question number 18. If a unit owner fails to pay their condo fees, the following is true. Letter A, the board of directors of the HOA can change the locks and restrict access to the unit until the fees are paid. Letter B, a lien can be placed on the property and the HOA may foreclose on it. Letter C, the owner loses their common area interests until the fees are paid in full. Letter D, none of the above. And the answer is letter B, a lien can be placed on the property and the HOA may foreclose on it. And as a matter of fact, here in Massachusetts, a super lien can be placed on the unit, which will jump in front of all other creditors, obviously not the government, but it can jump in front of the mortgage company. So here in Massachusetts, we have a condominium super lien law regarding HOAs or condo associations, and you do want to review your condo association rules and regulations, the ones that are at least presented in real estate courses, and you'll get a feeling here, and you'll see that there is a lien that can be placed on there. That's why we have a 6D certificate that you also learn about, which evidences that all condo fees are zeroed. Question number 19. Prior to submitting an offer to purchase, a real estate salesperson must provide their buyer with letter A, the tenant-led law notification for any home built prior to 1978. Letter B, the mandatory property condition disclosure form. Letter C, the home inspector's consumer fact sheet. Letter D, all of the above. Question number 19. Prior to submitting an offer to purchase, a real estate salesperson must provide their buyer with, and the answer is letter C, the home inspector's consumer fact sheet. So we want to know a little bit about all of these different disclosures. The tenant-led law notification for any home built prior to 1978, that isn't due prior to the offer to purchase being submitted. The mandatory property condition disclosure form, again, something that we don't have to worry about, but the home inspector's consumer fact sheet does have to be submitted prior to the offer being submitted. Question number 20. If a real estate salesperson receives a deposit check from a client or customer, they must letter A, deposit it into an interest-bearing escrow account within 24 hours. Letter B, deliver it to their managing broker immediately. Letter C, deposit it into an interest-bearing account within 72 hours. Letter D, deposit it into an interest-bearing account within 24 hours. Question number 20. If a real estate salesperson receives a deposit check from a client or customer, they must. And the answer is letter B, deliver it to their managing broker immediately. So remember, all salespersons must turn their checks over to their managing brokers immediately, or their managing brokers' representatives, operations, accounting, whatever is deemed as required by the managing broker. And the managing broker is required under law to deposit that immediately. And again, immediately is no further defined. So these specific timelines like 72 hours, 24 hours, 24 hours, not relevant. You want to skip all of those specific timelines, and you want to know that generally speaking, a salesperson turns over the check to their managing broker immediately, and the broker in turn must deposit that check immediately and that is no further defined. All right, thanks very much for checking out these 20 questions. I hope they were helpful with your studies. Remember, go through each one, pause the video, double check answers, double check things, try to understand why the wrong answers were the wrong answers, and focus on why the right answers were the right ones. Go over your notes from your class sessions, and I wish you much success on your real estate examinations. We'll see you soon.